Mr. Tinsley. You may bring the jury. Thank you. Good morning.
Good morning.
All right, ladies and gentlemen, welcome back. Day number 15, state's case. The last objection was sustained, and ladies and gentlemen, I want to remind you, when I sustain an objection, that means you're to disregard the question and any response. You may proceed.
Yes, sir, Your Honor. May it please the court. Mr. Tinsley, good morning.
Good morning.
Just to kind of reset the table from where we left off, you had testified about pursuing the case against the defendant over the boat wreck, correct?
Correct.
And you had communicated to the defense that the defendant was going to have to pay personally, correct?
Correct.
Not just the insurance.
Correct.
And you had been told that the defendant was broke, correct?
That's correct.
And you had filed a motion to compel. Had you filed a motion to compel, states 402, seeking to identify any bank accounts that he had?
In October of 2020.
Could I have the elbow, please? And the screen. David, if you can help. All right. I think one of the things that you had also testified to is that just generally COVID had kind of slowed things down in the court system.
Ultimately, yes.
And then you had had some health issues that you were dealing with as well. Is that correct?
At some point, yes.
At some point in time, did a hearing in the boat case that would include a hearing on this motion to compel that's on the screen get scheduled?
It did.
And when did it initially get scheduled?
My recollection is it was set for May the 30th, 2021.
All right, and let me show you an exhibit real quick. I'm going to show you what's been marked as States 404 and see if you recognize this document.
I do.
All right, and what is that?
That is a communication about the hearing. It's actually about a status conference about the hearing that's going to be on May the 30th.
Okay. All right, and what was the day of that status conference going to be?
May the 7th, 2021.
All right, and then look at the subject line on that and just take a look at that real quick.
Motions hearing May the 11th.
Yeah. Was that the date or was it May 30th for the motions hearing? To your recollection?
To my recollection, it's May the 30th.
All right. But this email is related to that particular hearing, is that correct?
It's related to the hearing on my motion to compel and some other hearings, yes.
All right. At this point, Your Honor, I move to admit States 404, I believe, without additional objection.
No additional objection.
And is that the particular email we were just discussing?
It is. And you're correct, the hearing was May the 11th.
May the 11th?
Yeah,
Okay. Haven't seen that. That refreshes your recollection?
yes.
We'll show you now what's been marked as States 405. And have a take a look at that and see if you recognize this.
I do.
All right, and tell me what this is, please.
It's an email from Judge Hall, who had been assigned the case, about the hearing. John Tiller, who was Alec's lawyer in the boat crash case, was diagnosed with pancreatic cancer about the same time, just before I found out I had cancer. And so He had a chemotherapy treatment that was going to run long the day of the hearing. He didn't always know when his treatments would be, but about a week before he would know. And so the hearing needed to be rescheduled to accommodate John's treatment.
All right, and just initially, when that request was made, what was the judge in that case's response?
The hearing would go forward as scheduled, and one of Alex's other lawyers could attend.
All right, so initially the judge denied that continuous request, is that correct?
That's correct.
And what happened after that that ultimately resulted in it being continued?
I sent an email. John Tiller was my friend, and I didn't object to continuing it. And then the judge had a status conference, and at that point, we continued the hearing until June the 10th.
In the course of this litigation, given that we were coming out of COVID, had the judge in that particular case been relatively aggressive in wanting to move this case forward, to your assessment?
The judge knew that I was in Florida receiving treatment and was accommodating that. No, he wasn't being aggressive at that time. It was when I was ready, and so I was back and we were ready.
And that's what led to this initial hearing, is that correct?
Correct.
But ultimately, you agreed to let this thing be continued, correct?
I did.
All right. Your Honor, this time I'd offer States 4 or 5 into evidence.
No additional objection.
Submitted.
And down at the bottom of this email chain, what's the date on that? Can you read there on your screen, or I need to bring it back to you?
May 5th, 2021.
And that's communication from whom?
That's from John Tiller to Judge Hall.
All right.
And that's relaying the need for the postponement for the chemotherapy treatment.
All right. And then there were the communications from you related to that, is that correct? Well, let me go right here. This is the response right there, is that correct, from Judge Hall?
That's the initial response, that he intended to go forward with the hearing as scheduled, and that Mr. Condon from the same firm could handle it.
Show you now what's been marked as States 406 and see if you recognize this particular document.
I do.
All right. And what is this? Tell the jury what this is, please.
That's an email from John Tiller. So after the email that's on the screen saying I intend to go forward, John Tiller sent another email explaining a little more detail what was going on, and that he had, I believe it says he had spoken to me and I had agreed. They were my motions. There were some other motions, but when it's your motion, you can agree to continue it if a party wants it continued and you don't object. And so that's what that's doing, and trying to get the judge to not go forward with the May the 11th date.
All right, Your Honor, this time I'd offer States 406 into evidence.
No additional objection.
Submitted.
All right, and the date on that particular email is?
May the 6th, 2021.
Did the judge ultimately, though, based on this series of emails, granted the continuance on this motions hearing, correct?
Well, he gave us a status conference in which we did by video, and ultimately he agreed.
Okay. And what day was the motions hearing that included the motion to compel rescheduled for?
June 10th, 2021.
Going back to States 402, one of the matters that was on the table to be heard would have been your attempt to get compelled responses to this interrogatory from the defendant, correct?
That's correct.
Seeking identification of his bank accounts.
That's correct.
You remember what day of the week? June the 10th, 2021 would have been?
I believe it's a Thursday.
How'd you hear about the murder of Maggie and Paul?
I got a phone call sometime in the middle of the night, 11:30, after my recollection.
And that was on June 7th, 2021,
That's right.
into June 8th, 2021?
I think I heard it's still June 7th when I hear about it, but yes.
On June 8th, 2021, did you have any conversations with any of the lawyers involved in the boat case or any communications?
I believe so. I think that it was more of, there wasn't a whole lot of consideration to be given to the fact that the hearing wasn't going to go forward. It was sort of shock and horror of what had happened, and nobody really knew what to do in the moment.
Of course, that hearing's not going forward after this,
It
correct?
did not.
We'll show you what's been marked as States 407 and see if you recognize that particular document.
I do. This is an email from Judge Hall's law clerk. Judge Hall's over the boat crash case to me and the lawyer for Parker's, as well as about the fact that the hearing's not going forward.
Your Honor, this time I'd offer States 407.
Additional objection.
So admitted.
What's the date of that email?
June 8th, 2021,
At what time?
4:24 p.m. I think there's an email from John Tiller that precedes this one that morning, but
Right. But ultimately, there were communications the following day that obviously we're not going forward with this hearing on the motion to compel, correct?
yeah, pretty much immediately.
And at that period of time, was there any date set in the wake of all of this for it to be reheard?
There was not.
In the wake of the murders, did you generally understand or have an idea of at least what had happened to Maggie and Paul, how they had been killed?
I did.
Just from media reports and the rest of it?
That's right.
And did that have any effect, that tragedy of their deaths, did that have any effect on your assessment of the boat case and how everything fit together, if things were how they initially appeared?
It would have affected, I mean, yes, it did, and it would have ended the case
It would have ended the case against who?
against Alex Murdaugh.
And explain that to the jury. Why? What had changed after this terrible tragedy?
Well, when you have a civil case, nice people get good verdicts, okay, just generally speaking. Yes, sir. Nice people get good verdicts. You really have to motivate a jury to want to help somebody in a civil case. And so if you compared, say, Attila the Hun with some sweet grandmother, who gets a better result? It's the sweet grandmother. If Alec is the victim of a vigilante, nobody's going to hold him accountable. Doesn't make any difference what he did or how clearly what he did contributed. The case would be over against Alec. And so initially, it could have been over. It appeared that it was going to be over against Alec because I had other defendants. I had Parker's convenience store that clearly violated its rules, and so you wouldn't want a very sympathetic person in your case when you have somebody who clearly violated the rules and caused this tragedy. So it would have been over against him.
The sympathies of the case had changed if Alec had truly been, his family had been the victim of some vigilante or something like that.
The sympathies would have changed if that had been true.
And assessing those sympathies and those emotions in a case like this is what you do as a plaintiff's lawyer, is that correct?
It's what we try to do.
And it's one Alec Murdaugh used to do as well when he was a plaintiff's lawyer.
I think he was good at reading people and knowing what made them tick.
Thank you, Mr. Tinsley. Nothing further at this time. Please answer any questions the defense may have.
Thank you.
Mr. Barber.
Good morning, Mr. Tinsley.
Good morning.
Maybe just start asking a couple of questions that I think are just some things that we could agree on before maybe getting to some other things. Was there any life insurance for Maggie or Paul?
I don't believe there was any life insurance on anybody, including Alec.
And if this motions hearing, which was not just the motion to compel, it was other motions, correct, on June the 10th?
Yeah, there were some other motions.
And if that hearing had gone forward, at least for the motion to compel, this would have been another step in a process? Right. In other words, I believe it was your previous testimony, I think it's fair to say that there wouldn't have been an explosion on June the 10th, that this would have been another step, but it wasn't the end point.
So what happens?
Is that correct, sir? Yes or no? Am I misstating your testimony? There wouldn't have been an explosion on June the 10th?
You're jumping around, so it's hard for me to follow.
I apologize.
Well, if you let me finish.
No,
Your Honor, I would like to ask the witness to be allowed to finish his answer to one of those questions, and I object to the form of the question.
Pose one question.
yes, Your Honor. Did you previously testify, I think that it's fair to say there wouldn't have been an explosion on June the 10th?
I'm sorry,
Yes
you
or
were
no?
looking down. I couldn't hear what you said.
I'm sorry, I was reading it. I think it's fair to say that there wouldn't have been an explosion on June the 10th. Quote. Did you testify, did those words come from that stand when you previously testified, yes or no?
I'm not trying to give you a hard time. You looked down again, and I could not understand what you said.
I
Was there an explosion?
apologize for that. I'll hold it up. I'm just trying to read it accurately. I think it's fair to say that there wouldn't have been an explosion on June the 10th. Yes or no, is that your testimony previously? Just yes or no,
It's possible.
please.
You're trying to turn it into something it's not, but I probably said words to that effect.
Okay. No further questions, Your Honor.
Any redirect?
You're asked about the motion to compel being another step in the process. Is that correct?
It was a way to put pressure on Alec.
Okay. But if, after that hearing happens, and an order granting a motion to compel had been issued, that starts a process that's going to run its course. Is that correct?
Objection, pleading.
If a order is, I'm sorry, I'll rephrase that. If a order to compel is granted, tell us about the process that happens after that as it relates to your specific interrogatory we've talked about here today.
Sure. The process starts on Alec's side way before. If you look at those exhibits that they marked the email, you'll see Danny Henderson. Again, Danny Henderson was his personal lawyer. Danny Henderson is also a shareholder in the firm. Danny Henderson is reviewing every single document. That's how meticulous Danny Henderson is. He reviews all of the account information before I get it. And nobody knows better what Alec's making than Danny Henderson. I mean, you'll see all these checks going out and all these payments being made, and Danny Henderson would have known. So the explosion.
Object, Your Honor. Objection.
Basis for the objection.
Foundation.
Response.
Your Honor, he is, speaking of,
Speaking of response to the objection.
he has testified as to the fact of his interactions with that individual who actually brought him insurance documents to review. I think he has a basis to know.
Foundation and your response to the objection.
I believe he has sufficient foundation to address that from his personal knowledge, Your Honor.
Overrule the objection. You may answer.
Thank you, Your Honor. For instance, I had subpoenaed the phone records, not only Alec's, his father's, but we also had John Marvin, Alec's brother's phone records. Danny reviewed those records for a long time before I could get my hands on them. Danny was involved in everything. He was at every hearing. He was at every deposition. He was intimately involved in every aspect of the case.
if an order to compel is issued, what was going to be your next step if you had an identification of accounts by the defendant?
Subpoena those accounts.
And if those accounts are subpoenaed, can potentially people move to quash those?
They could move to quash, but Danny Henderson would have looked at the documents in anticipation that I could get them.
Speculation.
I sustain the objection.
If motions to quash had been filed, though, you could have continued to seek that and there would have been further hearings, is that correct?
I would have continued.
Objection is sustained, that's the leading.
What would have happened if motions to quash were filed as to any subpoenas you issued to it for the specific information about the defendant's accounts?
I would have continued to push. We would have continued to argue about it.
Would have a process been put in motion, though, that was going to conclusion if an order had been issued on June 10th, 2021?
Absolutely.
Thank you. Nothing further.
Anything further?
No, Your Honor.
I step down.
Thank you.